हेलो एवरीवन। सो आज हम डिस्कस करने वाले हैं जीएस पेपर 2 के क्वेश्चंस के सॉल्यूशंस एंड यहाँ पर हम पूरा डिस्कशन डिटेल में करेंगे कि आंसर्स आपको किस तरीके से लिखने हैं और विद इन दोज वर्ड लिमिट्स उसका भी हम ध्यान रखेंगे। तो दिस वीडियो इज गोइंग टू बी इन इंग्लिश। ये वीडियो इंग्लिश में होगा और जिसको ये वीडियो हिंदी में देखना है सेम कंटेंट, वो नीचे डिस्क्रिप्शन में दूसरे यूट्यूब चैनल का लिंक दिया हुआ है जो कि हिंदी और इंग्लिश कंबाइंड का चैनल है। उस पर जाकर के आप इसका हिंदी और इंग्लिश का वर्जन देख सकते हो। सो दिस वीडियो इज गोइंग टू बी इन इंग्लिश एंड बिफोर वी विल स्टार्ट दिस लेट मी क्लैरिफाई फ्यू थिंग्स that I am just discussing the first half of the GS paper 2 in this first part. The second part will be released within a day or two. Okay. So the reason being because I will get into a little detailed discussion on the answer writing aspect also, because a lot of people face challenge with respect to how to write the answers with precision and also within the word limits. So this will also be a discussion to take care of those things because content is widely available everywhere. We will focus on content certainly, of course, because that is how we are going to be preparing the entire framework and structure of the answer. But more so our discussion will be focused upon exactly how you have to present your answer and how you have to write. That is the first thing. The detail of this entire framework, that means whatever this PPT is, it will be available. That means you need not to write anything. Everything will be available through a PDF. So in the description itself, there is a Telegram link given. You can go to the Telegram link and from there you can get the PDF of this entire answer structures. Okay. This will help you a lot with respect to your future preparation and will guide you, because the approach here is to learn how to write answers. Okay. So let us start our discussion without wasting much time. So the first question which is there, we have the right to privacy relating to self-identity is very dear to every human being and well protected under Article 21 of the Constitution. In this context, examine the effect of the amendment in 2026 to the Transgender Person Protection of Rights Act 2019. So the question is focusing upon the changes that have been brought in the 2019 Act. And you have to focus on what aspect? On the right to privacy aspect. So it says that right to privacy, first of all, you need to identify the keywords. Right to privacy, that is related to self-identity, right? It is protected under Article 21 of the Constitution. So before you examine the statement in this context, you have to write something about right to privacy with respect to Article 21 as well, right? And in the second part of the answer, which will be a little more detailed, you have to figure out the privacy issue with respect to these amendments. So what shall be the introducing statement? Because these questions which we are discussing are all 150 word questions. So a lot of precision is required in your answer writing and exact expression you have to use, like which is very compact and concise. So in this kind of language which we have to use in 150 word answers, you can many places you can do away with the conjunctions. That means in English language, the conjunctions like you can get rid of, with, for at certain places, but at certain places of course you will have to use it. And another thing you can skip at many places are the articles, where it is not very required, but most of the places where it is required you have to mention that. So this is how you can reduce the number of the words. So in these answers, I will try to stick to the number of words, but there may be a little escalation, because when you have to write 150 words, it is given, you can write a little more. And the reason being that provided, of course, that you can complete your paper. So 150 word questions, if they are there, you can go up to 160, 170 words, maybe up to 175 also. But in 250 words, you should rather limit it, because there is ample scope of limiting your answers within 250 words. So you can cut down certain number of words over there. But in 150 words, there would be more challenge. So it is going to spill over slightly above 150 words. So let us see this. This is how you can just write a very brief introducing statement in 150 words. No need to write very elaborate introduction and conclusion. You have to be very brief until and unless the demand of the question is such. So amendment to Transgender Act 2019 has raised questions regarding privacy. Now that is it. As simple as that. That brings out the context. Two things have been interrelated. and you have to write something about right to privacy first. So what shall you say? Recognized. See, we can start the statements like this. Instead of writing it is recognized as or fundamental right or right to privacy is recognized as, you can cut down the number of words. This is how, when you will follow these kind of structures, the answer structure which I am giving you over here, when you follow this up and practice it, you will automatically inculcate this art and you will directly come to using these expressions. So recognized as fundamental right, Article 21 will write in bracket. In Puttaswamy case, there's no need of writing Puttaswamy versus Union of India and year and all that. If you have scope, write the year. Privacy issue can be examined through triple test criteria: legality, rationality and proportionality. So two things we have mentioned. First thing is, we have mentioned that it is recognized as a fundamental right, in which case. Second is, what criteria are we looking at to establish this right to privacy as a fundamental right, in which this triple test formula has been given. Now this itself we can later on explain that how this can be applied to examine, right? That can be part of the concluding remark, that can be part of a just before the concluding remark also we can write that. So let us now proceed further. The new law and the privacy, how the privacy issue is related over there. So in the new law, there are many issues, but you have to pick up only those issues which are related to privacy. So what are those issues? Say, first of all, inclusion of categories of eunuch and persons forced to assume identity. Now, person have been forced to assume identity. Now, broadly speaking, what this law had been about? This law, as government says, it is trying to bring this law so that it becomes more easy for it to identify the transgender persons. It should be more on the objective criteria rather than on the subjective understanding. So obviously there is a conflict between the objective understanding and the subjective feelings on the basis of how you see your gender as. Those things have been somehow excluded as part of these changes that have happened. So herein the government has tried to change the definition and what all people have been included. So certain set of peoples have been included and certain set of people have been excluded. So inclusion of categories of eunuch and persons forced to assume identity. Those forced to assume identity may be who have gone through certain procedures, whether it is hormonal procedure, emasculation, mutilation or anything like that. These people, these have been included, right? This infringes privacy if forces screening or strips away self-determination. Because if these things are happening, then the person himself needs to declare there should be allowance for self-determination. Instead of that, it has to be determined externally by a particular authority. So this is where the conflict is. So this self-determination goes away. That means you have right to privacy because there's an encroachment from outside. Second aspect, excluding certain criteria like both trans women, trans men, the gender queer and self-perceived identities, they have been excluded. Even the people with different varying sexual orientation, they have been excluded from the definition. Now these criteria, trans men, trans women, gender queer or people with sexual orientation, this is something which cannot be decided only on the basis of objective criteria, on the basis of certain physiological physiological features. Rather, it can be decided mostly by one's own orientation and feeling. And therefore, right to self-determination is something very important. So these are highly connected to, strongly connected to privacy. These aspects which have been excluded, it's not there now. So that means right to privacy to determine all these things, your own orientation by yourself, it has been neglected. Second is, in place of self-declaration, it introduces external scrutiny by, that means wherever there has to be determination, then instead of self-determination, an external scrutiny is required. Now a recommendation of a medical officer is required, on the basis of which the district magistrate will be issuing the certificate. And the same thing will also go, this will go against the principle of self-determination, which has already been established in the NALSA versus Union of India case, right, which is related to transgender of 2014. And another thing is the same procedure of self-determination. That means an external institution will determine the person's fate, also with respect to wherever a revision is required. First of all, revision is mandatory now. That means if you are going for any kind of gender change, then you need to reissue your certificate. That means you need to get it revised. And this revision will also require the same procedure wherein you have to get a recommendation of the medical board. Earlier, the revision was not mandatory, right? There was a self-declaration. You don't need not every time to, declare it. So this is how we are saying that it is intruding into the sphere of autonomy, personal autonomy and privacy of a person. And therefore, this is challenging the right to privacy. Now, what is the government's clarification? Though this is not asked in the question, but very briefly you will mention that also, because that's how you will be concluding the answer as well. Standardized definitions and verification government is required for better identification and targeting, and so that this is how even the welfare programs can also be targeted and they are not misused. Whatever benefits are being provided to the transgender person, it is not going to be misused. Then it says that it will also strengthen certain laws against exploitation and trafficking, because in the law there is also a provision wherein a person who is trying to force another person as a transgender or making him to beg or do some labor work or servitude, then those people will be penalized, right? That is considered as an offense. So this is how government is saying that we are trying to strengthen this law is exploitation. But then this again befalls on very thin line, difference that would be there, and there will be a lot of controversy whether it's person is doing such an act by his own personal choice or whether he is being forced to. So there can be a lot of controversy in those areas. So this is how you will conclude this. Now, provisions may seem legally on track, but many may find, see, you have to use this kind of language when you are trying to not directly put a criticism from your side itself, but many may find it falling short. Okay, this is a very, language where you have to be a little diplomatic with your language or expression. Many may find it falling short on rationality. So I have used this word from where? From the triple test formula, because it is going to be tested. Even the word legally is there. So on the legal grounds, it may be fine, but on the basis of rationality, it may be questioned, right? So on rationality for understanding the gender problem. This word understanding is very important, is how you perceive the gender problem. This is what I had explained, whether there is only objective criteria being applied or even the subjective criteria is also taken into account in understanding of gender. So this is how you can present your answer. If you want to use certain structure or diagram or convert certain things into, like what I have mentioned as a point form, you want to show it in some form of diagram or block charts, you can do that. Overall, this answer was having how many words? 157 words. So this is a precise structure you get to answer the question. Exactly this is what you have to write in the answer. I mean, of course, one of the ways to write, you can always have different ways of writing answers. Of course, there can be even better way of writing it as well. But this is one of the ways you can write the answer. So this is how I have shown you that how you have to be careful, and when you are, when you read these expressions, right, when you will follow it from the answer structure, which I will be circulating on the Telegram, the link which is given, I have told you in the description. So just try to follow up with these expressions as to how they have been used, right? Apt number of words would be used, and apt explanation and precision will also be there, because you'll just figure out that is there any redundant word, remove it. And this is what you have to do when you write your answers. When you check your answers, go through the redundancies, like what words can I remove without, changing the meaning or without removing any kind of, not removing any kind of impact what the answer is bringing. Let us move to the second question. Second question, women as a class neither belong to a minority group nor are they regarded as forming a backward class. Now this is a quotation. Whenever a quotation is given in the question, if you can figure out, if you can guess from where the quotation has come, but I mean sure guess has to be there, you can somehow mention, if you know that okay this was said by Supreme Court in certain cases, then you can mention it. If you don't know, then it's never a problem, you can go ahead and explain it. In the light of this statement, discuss the evolution of women's reservation from local bodies to parliament. So what you have to do, in the light of the statement, we have to discuss the evolution. The main question is about the evolution of the process of reservation, how the women have got their reservation. So this needs to be explained first, and then we will explain the process of evolution. That means the question is not asking about the features which are included in the 106th Constitution Amendment Act. So that has to be mentioned briefly. We have to explain about the process of evolution. So how can we write the introductory statement? Statement explains the distinctness of women, right? So it's just we are making it brief only. We are just trying to explain the statement, explain the question. Introducing, statement would also always be an explanation of the question and getting into the context also. So statement explains the distinctness of women as weaker section because of patriarchy. This is what differentiates the problem of the women and the problem of caste groups or religion. And this was actually has been mentioned in number of cases. Supreme Court has explained this, but if you remember some case, there is a Pudili Murali case. This you can explain actually against the Andhra Pradesh government. It had brought a scheme by which was allotting the land plots, and under that scheme the land plots were allotted in the name of the women members of the household. So when they were allotted in the name of the women members, obviously the men had certain problems, and the program or the this entire scheme was challenged in the court. And the court had then made this statement regarding women, that their backwardness can be represented in what form and how it is different from other kinds of backwardness. And therefore there is a special provision also given for women, which is a general provision under Article 15(3) that can also be mentioned. Marginalization of women is irrespective of classes and minorities, right? Women, whatever minority groups, whatever religious groups, language groups are there, or whatever class groups are there, whether other backward classes, scheduled tribes or scheduled caste, everywhere the women, they have similar issues and problems. Of course, there are multiple whammies in many other cases, but women faces a lot of problem, and the basis is the patriarchal structure. So this is what the statement is trying to focus upon. We have explained this very briefly because the other part of the question we will have to elaborate. Okay, then what we'll say, let's see the evolution aspect, and we can start from the Balwant Rai Mehta committee, because a lot of people think that women reservation, it was given for the first time by these 73rd and 74th Amendment Act, but the issue of representation of women is pretty old. Even the Balwant Rai Mehta committee had recommended for 2 women members to be there in the panchayat institutions, right? And the Ashok Mehta committee had also recommended, but there was a difference between those 2 committees, because Balwant Rai Mehta committee had said that they will be co-opted members, the seats will not be reserved, right? So they will be basically not necessarily elected, they will be nominated. Here in this case of Ashok Mehta committee, the members were to be, 2 seats should be reserved for women. In that case, they will ensure that 2 women comes in case of Balwant Rai Mehta committee. So this was a recommendation, and the recommendation was also followed by many of the states. They had included this particular provision in their law. Now the LM Singhvi committee, it had recommended 1/3 reservation, that we know, for women in PRIs and ULBs, including chairperson's post. You can see that again in brief statements how we can maximize on information, because you have to talk about chairpersons also, and chairperson issue is a big issue, because that's a real empowerment. Because if the chairperson, women become the chairperson, then the other women also get empowered, whether they are normal women in the Gram Sabhas or whether they are the members of the Gram Panchayat. They feel empowered if the chairperson is women. So this has also been added by 73rd, 74th Amendment Act, and states started to provide based upon the constitutional provisions. States had changed their laws, they started providing. Later, many states, now I'm not saying states again here, states provided this. Later, many extended to 50%. Extended what to 50%? It's understood. No, everything you need not to explain, right? Don't repeat the expressions or the facts again and again. Later, many extended to 50%. Okay, then reservation in parliamentary institutions. Once this was given, then obviously there will be studies, there will be experiences. On the basis of studies and experiences and how the scheme had been working, we can think about the giving reservation to women even at the higher levels. Initially, in fact, it was thought that once the women, I mean, this is one of the arguments against giving the reservation to women in the parliamentary institution. Many people say that because they have been given reservation at the recruitment level, that means at the local bodies level, that itself should be seen as a forum for evolving or developing leadership, women leadership. And once the leaders come from the local bodies, they should automatically reach to the higher levels. So their reasoning is that just because at the recruitment level women has got the reservation is not required at the higher level. But then the counter argument would be that the patriarchal system or structure is such which doesn't allow women leadership to have an upward mobility. It's very difficult. And this is the reason the experiences of these bodies, they showed us that why women are not able to reach on to the higher levels, what are the problems, which essentially is deeply entrenched into the system, the patriarchal system, and therefore they started proposing for reservation for women. So you will have to talk about very briefly the reasons why the women reservation at the higher level parliamentary institution. When I say parliamentary institution, I mean to say both the parliament as well as the state legislative assembly. So what are the reasons? Underrepresentation, that itself is suffice. I mean, you can always use certain data at places to, justify your explanations also. But if you do not have the scope or you don't remember, you can skip that. Underrepresentation, only 15% women. This is a present data, so I can even mention presently over here, but that's understood. Presently, 15% women have been found to be there as part of Lok Sabha and only 9% in the legislative assembly. That means it is even worse at the legislative assembly levels, at the state level. Failure of the parties, how the parties have failed. Now, this expression itself explains that parties have failed to give them representation, give them ticket, allow them to come to the leadership positions. That's a failure of parties themselves. So you need not to give reservation if the party themselves are actually providing for it. Like for an exception could be here of the, you can write for example, exception Trinamool Congress, because it has sent a large number of women members in the parliament. Even in the Lok Sabha also it gave tickets to rather much bigger number of women members. Entrenched patriarchy is still a problem. When the patriarchy is so deeply entrenched, means that even when you are providing the reservation at the local level, as I said, the people are not able to rise. Or this patriarchy is there not only in the social system but also in the political system, because of which the women by themselves will not be able to come into leadership positions. Some kind of support or some kind of affirmation would be required for this purpose. Grassroots leaders not promoted, recognized. That's also not happening at the higher level, because most of the time you will find that the grassroots leaders remain at the grassroots level. And we have a parallel entries at the higher level. Of course, there would be parallel entries from different other avenues as well, but adequate number of people should also come from the local level bodies. They should be promoted to the higher levels. Very few are being promoted. It's not that they are not promoted at all. Gender sensitivity in policy discourse. If more women are there, issues will be more gender sensitive. Deliberations will be more women oriented. Women are more likely to raise the issues related to women. So these reasons can be given, on the basis of which there had been multiple efforts, multiple bills were brought between 1996 to now. You need not to write about all the bills because there's no scope, right? If you skip this part, but this part I think it's important to be mentioned, because that's a bridge between the representation that was given at the local level and the representation which is to be given at the higher level. So these reasons have to be there, you have to mention. So these bills failed. Why? Failed to generate consensus. Why the consensus could not be generated has been explained in the next line. Rajya Sabha had passed the bill in 2010 but met resistance from regional parties. So major issue is the regional parties, and the OBC issue was there, the class-based issues. And this is how it is connected to the statement also, because the statement itself is saying that the women issues should be seen in a very different context than any other class or minority groups. And the conclusion, see, because I am exceeding the number of words, so some information I am adjusting it in the conclusion itself, and that will not disturb the nature of the concluding remark. Finally, 106th Constitution Amendment provided 1/3 reservation in Lok Sabha and state assemblies, and within bracket I am mentioning article itself. Now, rarely it happens that we are writing the major information in the concluding remark, but here there is a possibility you can write, because this is what you had to explain till here. So Article 330A, 332A, 334A, you can even talk about 239AA for Delhi, but there's no need of writing all the information over there. Then though implementation is awaited, this awaited word itself brings in that very nature of how it's looking like conclusion, because that's you're talking about what next. You're talking about what is the way forward, what is the barrier. It is still not implemented, it is awaited. So I'm not saying it's not implemented, it's awaited. So we are in the hope that it will get implemented as early possible. Now, if you want to, if you have, not time in your hand, if you have space there when you have to write in your answer, then you can even talk about the sunset clause in 334A, which is of 15 years, or maybe when the women reservation is to commence. The question had been asked because of the entire issue that was there with respect to women reservation. That is how also you can start the introductory statement. I have used this particular introductory statement here because I wanted to explain the context of the question. Let's move further. Okay, this answer was in 162 words. So you can see that once you are writing these answers many a time, see what happens is, I'll tell you, you just go ahead and draw certain diagrams and you try to present things in as brief, but many a times it fails to explain. Language does matter. Within less number of words, with the precise expressions, you can actually convey, you can explain what you want to. This is I want you to pay attention to and to learn from these answer structures. And these structures, go through them again and again and try to see what you can learn from these answer structures. Okay, question number 3rd. Examine whether the constitutional office of the Lok Sabha Speaker has become vulnerable to partisan politics under the current anti-defection regime. What institutional changes are required to ensure the neutrality of the Lok Sabha Speaker in managing a polarized house? See, the question is strongly connected to the disqualification of the TMC members, which was asked for by TMC. I mean, the rebel TMC members, they were joining another party. In that case, the Lok Sabha Speaker had been delaying the decision. So there it was alleged that he is acting in a partisan manner. And therefore, there was a plea which went to the courts as well. Now the question is, we can use that in the context also, but then there have been a number of other issues. See, this question though is reflecting, talking about Lok Sabha Speaker, but the problem has been seen more at the level of the state legislative assembly speakers. So you cannot neglect the two issues are important, because if the reforms or changes are going to happen at one level, it will happen at the other level as well. So we'll contextualize it a little generally. What we are saying in the introducing statement, partisan conduct of speakers belonging to ruling party. Now see, added information over here itself, because I will have to otherwise write one more statement saying that why the speaker behave in a partisan manner, because the speaker happens to be from the ruling party. So belonging to ruling party under anti-defection law 10 schedule, you see how you can making all the information compact, has sparked debate on his sweeping powers as final authority under para 6. So in 150 word question, okay, remember in 150 word question, you can always mix up introduction with certain facts also, which you have to write separately. Right? This way you are using introduction itself to convey or put in more information. Same thing can happen with respect to conclusion also. In 250 word answers, you will have ample space to write, right? So there you can make your introduction and conclusion very distinct. But in 150 words, there will be challenge. So these are the kinds of things you will have to do. Right, so this final authority you can even underline. Now I have not shown the underlines over here. There are certain keywords you can always underline, or you can put in boxes, or you can make them bold as well. Okay, so this was the introducing statement. Now what we are trying to say, arbitrariness on the issues. In one statement we have included all the issues which are there in number of ways the speaker had been acting in a partisan manner. and you had to examine this issue, right? And when you have to examine the issue, that means you have to talk about these issues and where they had emerged and then what was said on this. That means you have to talk about cases. So arbitrariness on disqualifications, decision making time, interpretation of voluntarily giving up member, because this is a major issue. Someone who is voluntarily giving up membership, if the party doesn't condone, then in that that is related to whip. If someone is voluntarily giving up the membership, is something very subjective. Another measure is related to where the party is issuing the whip, right? So on the issue of whip also, the whip issue can also be included. I have not included it because of the number of words. The whip issue could also be included. Forget about that. When you say voluntarily giving up, someone who is voluntarily giving up the membership of the political party, in that case, he will be seen as defecting and he will be disqualified. So what do you mean by voluntarily giving up the membership? What do you mean by this? This has led to a lot of debate, because many a times what happens is the person actually doesn't formally quit his party, but he is doing everything against his party. So there are assumptions made by the speaker that this particular action of the person, like for example, there are people like Mr. Subramaniam Swamy, who will always speak against his own party, right? There have been many people in the BJP who had been taking a very strong, not only different stand is fine. You are allowed that kind of dissent, but when you are going against your party principles, party discipline, you are showing as if your loyalty is with some other group or some other party, then those actions can be seen as if you have voluntarily given up the membership. And this provision is also being misused by the speaker, right? Etc. have been dealt in cases. What cases? Let's just write few. Now I have written a number of cases. For paucity of space, you can skip also one or two cases. Among the very important cases, the Kyoto Holohan versus the Chulu 1992 case. In this case, the para 7 of the 7th schedule, it was struck down because para 7 says that there cannot be judicial review over the decision of the speaker. So the speaker is deciding, he said, is a final authority. He is a final authority, but now it is subject to judicial review after the Kyoto Holohan case. So this is a change in the position, and there had been controversy. Rajendra Singh Rana versus Swami Prasad Maurya case, 2007, speaker's decision was set aside, whatever decision was made by the speaker, because here again, speaker had been acting in a partisan manner, right? Few members, they had approached him for disqualification of certain members. So speaker had gone ahead and done it. So this was seen because they were trying to support the party which is there in the power. So speaker was acting in a partisan manner. So speaker's decision was set aside and declared unconstitutional, and it was actually decided by the court. So this also, we say that he's a final authority. Now the court is deciding instead of speaker. Who's the court to decide on behalf of the speaker? That again is question. Speaker's decision may be invalidated as a different issue, but instead of speaker, if the court is deciding, this may go against the parliamentary norms or parliamentary, what we say, credentials. Ravi Nayak case versus Union of India 1994 subjected speaker's decision to principles of natural justice. While making the decision, the speaker has to be fair and reasonable. He has to follow the rationality and give fair chance of explanation. Maybe he will not just listen to one side and take the decision according to that. He should allow the other side to also give their explanation. This will be part of natural justice, basically the right to hear on the other side. Kishan Singh, which is related to Manipur Legislative Assembly 2022, fixed 3 months for deciding disqualification here in this case. So this will give you some hints as what suggestions can be given, that there has to be a time limit within which the speaker needs to decide on disqualification. Namam Rabia, very popular case in Arunachal Pradesh. The speaker facing removal disabled adjudicating disqualification. That means speaker facing removal means if a no confidence motion has been brought against the speaker himself, then he should not take the decision on disqualification of member because there is conflict of interest over. So these are some important cases. If you want, you could have skipped maybe the Ravi Nayak case, you could skip. Even Rajendra Singh Rana case also you can skip. But Kyoto Holohan, Kesham and Namam Rabia, these 3 cases are very important to be mentioned. Institutional changes, what is recommended, because this is also asked in the question. So what changes? See, disqualification, powers transferred to an independent body. This has already been recommended by National Commission on Review for reviewing the working of the Constitution, and the second ARC, they had recommended this, that why should Speaker be deciding on the disqualification? Rather, disqualification should be given to a separate body, a quasi-judicial body, which may take the recommendations of the Election Commission also in the decision of this body, of this. But then this will also, if the recommendations of Election Commission is given, which has been recommended by at a number of places, then even the Election Commission position will also be politicized in that case. So you have to be careful. A statutory deadline of 3 months can be fixed for taking disqualification discussion inspired from that case. Necessarily resign from party, no membership again. That means whenever someone is speaker, I mean, you need not to again write all the detail. It's understood. Necessarily resign from party means the speaker will resign from the party once he becomes a speaker. And then he should not take the membership of any party. This is a position that is there in Britain. That's an example we have written. So we can follow up that. I think that's important because the speaker's position has to be elevated, right? It has to be, seen within the framework where the neutrality is maintained completely. And the speaker's position is a very important position. Speaker is chairing the most important institution in the country. So this way he happens to be perhaps one of the most important posts in the country, which is somewhat equivalent to that of the president and the prime minister. And therefore, this can actually be recommended. Even, I will tell you one more recommendation, which is a little more extreme. No further appointment to any office of profit in the government. I think this can also be included, though in a way it's understood, but then it has to be followed. Bar on pursuing active politics altogether. But I have mentioned here maybe, right? Because it may become a little extreme recommendation, but still it can be thought. I don't think there is any harm in barring from, because they can retire from politics after being speaker. But then again the question is that if someone at a very young age is appointed speaker, then what? His entire political career will be sacrificed in that case, or should we only appoint people who are at the fag end of retirement? So that's why I put in maybe. This may not be a very good recommendation, but still we can mention it. So this may bring neutrality in his overall conduct as chairperson. Very brief, because most of the things have already been explained. 166 words. You see, all the explanations have been given, the points have been included, and it is compact as well in terms of number of words. Okay, question number 4. Is the right to vote a fundamental right? Discuss the position of the Election Commission of India while undertaking the revision of electoral rolls. Can it also examine the question of citizenship of voters? Now, I think this question, it wasn't that easy, because the exact position which has been there in the ADR case, what was presented from the side of the Election Commission with respect to voting rights, with respect to citizenship, is what is to be mentioned in the answer, right? So it's not that easy, but then of course it depends upon how good your current affairs material had been. That will include all these aspects. Okay, before I go further, I wanted to make 2 more announcements. One is that we will have our polity and governance module starting shortly, wherein I'll be taking up the entire module of polity and governance on the Academy platform. We will make that announcement very soon on the Telegram channel as well as on this YouTube channel. Okay, and I repeat that those in the Hindi medium, जो भी लोग हिंदी मीडियम के स्टूडेंट्स हैं, please follow the other link which is given in the description. There is another YouTube channel, and we will post content in English and Hindi both over there. That means the entire explanation would be in Hindi except for the terms, and the write-ups will be in English. Okay, and one more announcement, and that is I will also be launching from next month the current affairs monthly for polity and governance, because now it is very clear that the mains questions are almost all the questions, they are rooted in some current issues. Okay, sometimes UPSC goes a little back also and asks for 2-3 years back issues as well, but most of the time, this time you can see it is something, or most of the issues have happened this year itself on which the questions have been asked. So it is very important that we follow the current affairs properly, Those current affairs will be useful for both prelims and mains, and along with that I will also give you the entire detailed document, will be a whole foolproof material for your preparation on polity and governance, right? Video as well as whatever content will be there in the form of PDF. So you can follow that, and please follow the Telegram channel which is given there in the link, because we already post a lot of current affairs material on daily basis, and almost all the daily important current affairs material is already there. And plus we will also be posting up these monthlies on certain issues, and later on maybe we'll be bringing out a monthly overall current affairs magazine as well. Okay, so let us see this question. Now here is a right to vote of fundamental. Discuss the position of Election Commission of India while undertaking revision. So you have to talk about Election Commission, what is its stand on right to vote and on citizenship issue in the entire SIR process. What stand was taken by the Election Commission? Okay, so what say? Amidst controversy related to voter religion under SIR, emerges demands for recognizing right to vote as fundamental right, because that's why they are asking you that should it be fundamental right or not. So from where has this popped up? It has popped up because a lot of voters, they have been deleted. There are a lot of allegations have been made that there are arbitrary deletions under the special intensive revision process, and therefore many experts and intellectuals, they have made this demand, and even in the court the demand has been made that the right to vote should be recognized as a fundamental right. So we'll have to clear this position that is it a fundamental right? Of course it is not, but then what is the position? So the traditional view that is there on right to vote, as is well established in the Punnu Swamy versus Returning Officer case 1952, in the Kuldeep Nayyar case 2006. In fact, there's another case of Mr. Jyoti Basu versus Devi Ghoshal in 1982 also. It was said that the right to vote is a statutory right. Court earlier had not even maintained it as a constitutional right, though right to vote actually should be seen as a constitutional right because it is derived from Article 326. It is your right, your entitlement to get registered, from where itself right to vote is sourced out. So it should be seen as a constitutional right. But in all these years, court had been saying that right to vote is a statutory right, because the reason why it is saying is statutory right, because it wanted to give powers in the hand of the parliament to give the voting rights to the people, because voting rights could be restricted also. There may be certain disqualification also, and which the law itself will determine. If you will say it's a constitutional right, then it will be more better protected. And then this brings down the power of the parliament to define maybe certain conditions or terms, or maybe every time people will get into litigation claiming it to be constitutional right. And imagine if it is declared as a fundamental right, it will become even more protected. And in that case, what will happen? It will become even more difficult for the parliament to restrict voting rights through certain procedural safeguards. That means in order where a person has lost its citizenship, or maybe where he has been disqualified for any other reason, it will be difficult to do so. It will be difficult to take their voting rights, right? Which will be a genuine takeaway that will also be challenged every time in the court in the name of fundamental rights. But then later on, this position has changed as we ushered into a stronger realm of rights, especially 1980s onward. You see the trends of fundamental rights becoming more after post-emergency scenario. But it is only in the 2000s onwards this will enter into fray as far as the right to vote is concerned. Right to vote started being linked first to the constitutional right, and later many aspects of right to vote were related to fundamental right also. But as of now, it has not been declared as a fundamental right. So there's a changed position in the People's Union for Civil Liberties in 2003 case, in Anup Barnawal case. In all these cases, court is saying that right to vote is a constitutional right sourced out from Article 326. In fact, in the PUCL case and in some other cases also afterwards, like for example here they are saying that they have the right to vote, and the right to vote also means freedom to vote, freedom to exercise your right to vote. Having the right to vote is one issue. Freedom of exercising your right to vote is another issue. And freedom of exercising your right to vote Supreme Court in PUCL case says that it should be part of freedom of speech and expression because vote is your expression. So this is how the right to vote connected with freedom to right to vote has entered into the realm of fundamental rights. It has started from PUCL case itself, but by itself right to vote was not declared as a fundamental right. These are the arguments nowadays being given that the right to vote is entering into the realm of fundamental rights. So this change position, it's a constitutional right. Then we say as of now, it is not recognized as fundamental rights. A number of cases, even for that matter, another case of People's Union for Civil Liberties and then the ADR case also, the Nota case itself, the Supreme Court had said like freedom of not giving the vote to anyone is also part of your fundamental right, freedom of speech and expression. Again, connected to right of vote, but not itself a right to vote per se. So there are many aspects of right to vote which may be related to fundamental rights, but right to vote itself is not a fundamental right. Demanded for what? What is the reason? That also you'll have to give now why it is being demanded as a fundamental right, because that's the position. Is it a fundamental right? No, not. Can it become? Maybe. Yeah, there is a demand on certain basis, so you'll have to write protection against arbitrary deletion. That's situational. That's why it is demand is being made. That's understood. Second one is popular sovereignty. This is interesting that we in India, we have a popular sovereignty. You say we the people of India have given to us our constitution. If there is a popular sovereignty and not a parliamentary sovereignty, then the people are above the parliament. And the people's sanctity will be maintained by their rights. What Dicey has given is three principles. The third principle of primacy of rights, which is not actually applied in case of India, but is applied in case of US. Some element of primacy of rights is here. Because people have rights, they have the constitution. Because they have right, they have law. Right? So because they have the right, that's why the government is there. So their right to vote should be seen as superior to parliament. It should be seen as even part of basic structure of the constitution, which cannot be taken away. And how can it become? Which right could be part of basic structure of the constitution? When it is declared as a fundamental right. So that popular sovereignty element is there. And then the evolving jurisprudence is a judicial philosophy of how it is perceiving right to vote. Because earlier it was seen only as a statutory right, then as a constitutional right. And then here, like for example, in Nota case, it says that there are connect with fundamental rights. In a PUCL case, there's a connect with fundamental rights. Even freedom to vote is part of related to right to vote. So this you can write. Maybe the word limit will exceed because the question is very precise. Otherwise, we can write certain examples also of the cases. Okay, now let's say what is a commission stand on right to vote? Now, very precise. What is the stand of the commission on the right to vote? Commission had made certain arguments in the court related to what it thinks about right to vote with respect to SIR. Now, SIR means you are deleting the voters, or you are taking away the right to vote. So the right to vote, should it be fundamental right? Election Commission will say no, it should not be fundamental right. Should it be constitutional right? Maybe it could be, but then the parliament has a power to restrict it. Restrict it through certain procedural safeguards, certain procedures which should be defined, on the basis of which someone's right to vote can be taken away. So in that case, let's see what Commission stand on the right to vote. It recognizes its right to vote as a statutory right, but then it says it is fundamental to democracy. Yes, but it is not absolute because there can be restrictions. And of course, if it is a statutory right, the parliament can put certain restrictions also on the right to vote. Lawful restrictions is possible subject to procedural safeguards. So you will underline the words procedural safeguards, absolute and statutory right. That's the position of the Election Commission on right to vote. And then it says also, which will connect to the larger process of the SIR. Integrity of elections inextricably linked to the correctness of rolls. And for correctness of rolls, it may be important that certain people's right to vote needs to go away. Because they are not eligible voters. They are not qualified on correct grounds. Right? They may have by forgery or by fraudulent means have acquired the right to vote. So they need to be removed. that power has to be there. So the integrity of elections is inextricably linked to the correctness of rolls. So underline this, correctness of rolls, that's an important keyword. And election commission stand on the citizenship issue now. What it says about citizenship, because the question here is of determination of citizenship. Because when you are conducting this entire SIR process, then the documents were asked for, and wherein they are saying that there's already a controversy as to which document will be considered citizenship document. There's no such document, universal document which establishes citizenship. So that issue was there. Then if you have been removed from the voter list, then probably you are not a citizen, but it is not sure that you are not a citizen. So that means there has to be a proper adjudication process thereafter. And citizenship is linked with voter right, because one of the conditions is that you have to be a citizen. And if you are no longer a citizen, which is mentioned in the law also, that if you are no longer a citizen, then your name will be removed. So if your name is removed, saying that probably you are not citizen, so election commission is on certain grounds saying that you doesn't seem to be citizen, but after all it needs to be adjudicated by some other body also. So election commission's power will not be complete. Election commission by itself will not have the power of determining citizenship. It is only doing an inquiry on the citizenship, not determining the citizenship, which has to happen according to the Citizenship Act of 1955. So power to examine citizenship flows from Article 320. This is what says power to examine citizenship. This power is there with election commission. Under Article 325 and 326, both the places it has this power where it can question, it can disqualify people for non-citizenship from voting. And the same is mentioned also in the representation of section 16 of the Representation of People's Act. So case not of determination of citizenship, but an inquiry into eligibility for enrollment. This is the key statement. Even if you get rid of other statement, this is the most important statement which have to be mentioned. That's the stand. Then it says this examination is not exclusively with the Home Ministry. It's not just the Home Ministry under which the entire matter of citizenship is there. It itself will determine, but there are other authorities also who have been empowered with respect to examination of citizenship at least. Right? They can inquire it. But ultimately, who will decide on the citizenship, whether a person is a citizen or not? That is there to be decided by the Home Ministry under the Citizenship Act. But the examination can be done. On the basis of certain disqualifications can happen. Because the same criteria is there, with respect to the members of the parliament and all, right? That they have to be citizen of India. So if they are disqualified, then their membership also will go. Or for that matter, the position of the president, vice president and all. Citizenship not ceases on ineligibility of electoral roll. For some reason, even if you are thrown out of the electoral roll, it does not mean that you have lost your citizenship. So this was a stand, and in fact the court had accepted the stand of the election commission in the ADR case. In fact, court did give a lot of directions in the ADR case to the election commission to increase the number of documents that we know, by which it contradicted also the entire process of the SIR, but mostly it accepted the view of the election commission as far as right to vote and citizenship was concerned, and overall SIR process was concerned. Election commission may undertake limited inquiry through, this is our final say in this matter, but actually this is the you can say the stand of the court, right? Even you can add this also, that according to Supreme Court, this is also how you can conclude. Election commission may undertake limited inquiry through calibrated approach on citizenship and voting rights following procedural safeguards. That's how we can conclude this answer. Now this question would definitely have exceeded the word limit slightly, but some questions you will have to exceed the word limit. Otherwise, you will not be able to answer it with that appropriateness. But there is a lot of scope in cutting down one or two points here and in the previous, stand also of election commission on right to vote. So that can be removed. Overall number of words is 177. So if you will combine maybe one or two of these statements or skip. Now I haven't done it purposefully so that you get a complete information related to what had been the stand of the election commission. Okay, next one. Do constitutional bodies like National Commission for Scheduled Caste and National Commission for Scheduled Tribes possess adequate enforcement powers to secure substantive social equality? suggest measure to enhance their institutional effectiveness. So this question again has been asked because something had happened in the current, and very recently in the year 2006 itself, there was a case where the Supreme Court had made this judgment in the Mumbai Port Authority case. Now in this case, what had happened was there was this staff or a stenographer in the organization who was demoted because they had prepared a new seniority list, and according to that she was demoted. So she goes to the National Commission for Scheduled Caste and with her service matter, and the commission, it ordered the authority that you need to get her position back, right? So then the Mumbai authority went to the High Court to challenge the order of the commission. High Court also supported the National Commission for SC, saying that no, she needs to be again, her position needs to be restored. Ultimately, the Mumbai Port Authority went to the Supreme Court, and the Supreme Court had made a change in the decision. Supreme Court now says it questions certain powers of the National Commission for SCs, and it has also applied it to the STs and also to the backward classes. Let's see how. So what we say in the introduction, we will write about that case itself. Supreme Court clarification in Mumbai Port Authority 2026 that the National Commission on SC's role is strictly advisory and recommendatory under Article 338, puts questions on its enforceable capacity for social equality. So I have explained the question also, I brought in the context also, and included certain facts also. All three things in this introducing. That's why the introductory statement, introduction, has become a bit lengthier, because I have included certain parts, some facts also over there, which otherwise I would write as part of the body to make it more compact. Okay, so here court has made clear certain things in this case. What further things have been made clear? It says that the commission can't issue binding or enforceable directions, particularly in service matters. So this is important, that it cannot issue binding directions in service matters. Particularly, that means it cannot issue binding matters, but in service matter for sure. That means there is a slight loophole in this, in the interpretation of this decision, right? So maybe at a different stage in other cases, a little different stand may be taken up by the courts. But overall it says that it cannot issue binding or enforceable directions, and that also means the orders, right? See, the commission, it has got the power of seeking compliance from the executive bodies or authorities. It can tell the government, ask the government to do something. It can only seek compliance. The question is whether it can actually order, and that order is binding or not. So now the court is saying that the order is not binding. It is not enforceable, and in service matters, definitely not. Article 338, Clause 8 grants only procedural powers of a civil court. That means it is a quasi-judicial body. It has certain powers of a civil court, but it doesn't have all the powers of the civil court. And therefore, for the purpose of investigations only, it has got certain procedural powers, and that is summoning and witnessing, taking witness, or maybe asking for affidavits, or calling upon someone to give or some information. All those powers which is there with the civil court it has, but only the procedural powers. It doesn't have the substantive powers of a civil court. Okay, next one, it says no authority to enforce compliance. I mean, there's the same thing, but with respect to the compliance it is mentioned from the executive body. Limitations also apply to the National Commission for ST and for backward classes as well. This is what was mentioned in the question, so it's important to be mentioned as part of the judgment which is given here in this case. Okay, it says that National Commission, this is what we are saying, I mean, as part of the functions of the commission. This is not the court. See, look at the bullet points here. This much was the court's ruling. Okay, now we move to the next bullet point. Next bullet point is what we say is that National Commission for Scheduled Caste, it has certain powers. What powers? Recommends legal safeguards and policies. It recommends policies and legal safeguards, and reporting, monitoring, etc. So there's a long list of functions and powers which we go through, but we are just picking up important ones which are related to its substantive power, where it can make or create some influence as far as the substantive equality in the society is concerned. So that's why we have to mention some of these functions to say that it has certain powers. can influence, that means NSCN can influence and seek compliance for substantive equality. But here we should also add one more term, seek some compliance, okay, from substantive equality, but has to depend on the executive agencies. That means seeking compliance doesn't mean that your orders or directions are binding, right? But it has certain influence, certain powers, where of course, because when the executive is not doing something, when the National Commission is saying, then the executive becomes answerable and executive can be asked questions, and even in the parliament. But of course, this position is not strong enough as far as National Commission for Scheduled Caste is concerned. So this is how we will give a suggestion also as to how to empower this body. So what measures for effective body? First of all, we need to ensure independent appointment of the members of the National Commission for Scheduled Caste, Scheduled Tribe, backward classes. This is all done by the government. So it is not an independent appointment which needs to be. Second, maybe something like NHRC, which has a very comprehensive committee for the purpose of appointment. That can be suggested here also. Maybe not as many members, but at least there has to be an independent body which will determine this. Next is government should explain the rejections of recommendations. This is what I mentioned. Now see, independent appointment, maybe we can give something similar to NHRC, and government should explain rejection of recommendation, something similar to Finance Commission. Like in Article 281 of the Constitution, it is mentioned, no, that if the Finance Commission, when it is giving its report or recommendation, it has to give an explanatory memorandum. In the Parliament, it has to place it. So it means the government becomes answerable when it is not accepting the recommendations of the Finance Commission. So same thing should happen here also. If it doesn't accept what directions have been given, what compliance has been asked for from the executive by the National Commission, then the government should be answerable. Statutory limit for disposal of cases should also be set up. Means in the law we have to, in the Constitution or maybe in the rules, we will mention the timelines in which the cases need to be disposed, because here we can mention this disposal of cases are related to what? Disposal of cases are related to, maybe example you can write is the Scheduled Caste and Scheduled Tribe Act of 1989, or maybe the Protection of Civil Rights Act of 1955. On these matters, there is a lot of pendency over there, so the time limit needs to be established. Real-time monitoring of pendencies. Now, this has been also mentioned over here about the reservation matters, the service matters. A lot of pending cases are also there. So there has to be monitoring as well. Then the expenditure upon the consolidated fund should have financial autonomy. That means whatever expenditure is made, the grants are given, it is given by the Government of India. And this is like a budgetary grant. That means it is voted in the Parliament. It is not like the expenditure charged upon CFI, which cannot be questioned by the Parliament. So here the proposal can be that the expenditure should be seen as done from the CFI, so that it becomes a fixed expenditure and it cannot be questioned. This will increase the independence of the Commission. And more regional branches for expediency should be there. Finally, you can conclude saying that overcoming these measures, the problems, of course, which are there, may help promote fair mechanism of independent grievance redressal for substantive social equality. How you connect with the question. That's how we can conclude. Next question, let's move further. Now, this was 169 words, right? So again, a little exceeding, maybe 1 or 2 points. Yeah, I have not compromised on the dimensions and the number of points, right? But of course, your answer will exceed. 150 words answers will definitely exceed. They will definitely exceed by 10-15 words. No harm. And certain things you can put in diagram also. I'm not showing the diagrams over here because I wanted to emphasize on the languages and expressions. Even if you are writing or creating a diagram also, remember that the expressions, either you are explaining elsewhere or the apt explanation has to be there, no matter brief, but which should convey the idea. That's important. Does India's tribal development policy reflect the aspirations for a socially grounded and equity-based governance? Justify your answer. Now, this in the context of repeatedly we see often that there are demonstrations and protests in the tribal areas, especially with respect to the mining in Odisha. There have been a lot of issues even recently, like the Kutrumali mines, and there are many Khond and the Khan tribe. They have been doing that protest. Earlier it was with respect to the other mines which were allocated to some Vedanta group and all of them. So how we'll just put it, just an explanation of frequent adoption of tribal issues. Example, mining in Odisha, including land and forest rights, asks for reviewing of development policies, or maybe for continuous review of the development policies, because how the policies are made, that also is a question. Here the question is not about implementation. Implementation, of course, is going to be a major issue. See, in the question we have to justify, are these policies good enough? Are these policies good enough that they are socially grounded, and are they equity based, or maybe what are the problems with the policy is what we have to look into. So first thing we'll explain is aspects in policies which actually suggest that it is socially grounded and they are equity oriented. So whatever policies the government, policies means whether it is certain laws, whether it is programs and schemes, or whether it is actually the tribal policies which have been made, or on certain issues which have been made, majorly about programs and schemes, are they conforming to this idea or are they not conforming to this idea? So what we can think about, that how policy is equity oriented, or the tribal policy, what should be there that makes it equity oriented, what makes it bring social groundedness. So we will just try to classify that into different categories. So this one I will show in the form of diagram. You can even write in point form, but let us just see that the policies, they have so many dimensions. These dimensions itself is telling that they are socially grounded and equity oriented, and we will mention certain examples also that how it is being achieved. So we say that yes, policies have the element of social groundedness and equity. First is policies. Certain policies are there which helps in overcoming entrenched inequality and discrimination. Entrenched inequality means equality which is coming from the past, which is part and parcel of the social structure. How we have secluded the tribals from the mainstream, right? And the discrimination which persists, resolved by reservations and resolved through the National Commission for Scheduled Tribes. Second aspect in the policy could be providing equality of opportunity. Now this aspect may be related to it, but there's a large equality of opportunity through education and health and employment and other areas. What are they? Eklavya residential model schools are there. Pre and post metric scholarships. DAPST, the program, even Dharti Aaba, both these programs related to how the infrastructure in the tribal areas, they can be improved, how the services can be improved, which is providing them a better opportunity, a fairer opportunity. The third dimension, protecting rights and ownership over resources. So here we'll give the examples of Forest Rights Act and the extension of Panchayat in the scheduled areas, 1996. Another dimension of it being socially grounded equity is the targeting most vulnerable, like PM Janman, which is related to these Janjati and Adivasi. Nyay Mahabhiyan, which is there with respect to the particularly vulnerable groups. For them, more targeted program is there. Then we have the economic opportunity and market fair play, which is coming through one Dhan Vikas Yojana with respect to the National Scheduled Tribe Finance Development Corporation and TriFed and BBG Ramji. All these helps in creating more economic opportunity and bringing market fair play. So these are the aspects, right, of equity and social groundedness. Next is empowerment and participation can come through the PRIs, Panchayati Raj institutions, and the reservation which is there, PESA and FRA, again repeated over here. And socio-cultural identity can come through the 5th and 6th scheduled tribal research institutes and festivals. See, in this diagram, what we have tried to do is that we have shown different aspect or dimension, how we are explaining that social groundedness and equity is coming in these policies along with the examples. Now we will look at the shortfalling, that why this is missing. The policies may be in place, but there may be certain problem with the policy or maybe certain problem with the implementation itself. So let us see the problems. What are the problems? Challenges remain because of lack of awareness and mobilization among the tribal itself and the parochial tendencies. They are living in their own world happily. They are not connected to the mainstream, neither they are bothered. And this itself becomes a policy question. To what extent can we interfere in the tribal areas? What is our perspective, perception of the tribal way of life? We look at from the modern perspective or the postmodern perspective. We look at from a top-down approach, from the bottoms-up approach. So those models of development itself have a lot of contradictions that will become a problem. So we say contradictions in development approaches, right? Like there are number of meta narratives that how the problem of underdevelopment needs to be resolved. Is it only through modernization, or can there be very many different alternative mechanisms and ways? What's happening, how the, even with respect to Andaman Nicobar Island, that could be the context of why the question has been asked. Because the Gram Sabha's approval, how it was taken, just a formal procedure. Maybe the real consent of the Gram Sabha many a times are not taken in approving the projects. Just their members are asked, or maybe sometimes even pressurized to sign and give their approval of certain industrial projects or mining projects. Imposition of ethnocentric policy models. That means policy model which is not coming from the realities of the tribal areas, rather which has been dictated from elsewhere. I mean, understanding of some other norms, some other cultural realities. On that basis, we are trying to impose a policy on the tribals. That's a policy question. Like these are the problems in the society of the tribals. These are the problems in the policy itself. Then there is a bureaucratic delivery, of course, all hell lot of problems. We can only write in brief over here, just mention bureaucratic delivery. That means too much focus on the means and the procedures rather than looking at the end result, what's happening on the ground, and focusing welfare saturation, more on the welfare saturation than real empowerment. That means it's again is an approach why you mean to give something to the tribals rather than let them have it by themselves or empower them so that they can resolve their own problem by themselves. Gram Sabha's consent is a procedural formality. You can write example also here in bracket, right? In case of what happened with respect to mines in Odisha or in Andaman Nicobar, especially the Nicobar project which is going on, how the approval has been given. National Green Tribunal and all that, you know, how justifications have been made there. Administrative fragmentation ignores holistic planning because there are many departments, different aspects which are to be delivered in tribal areas, maybe under different agencies, and there's lack of coordination and the holistic inputs doesn't even come for planning purpose. Therefore, fulfilling social grounding and equity based governance lies more at implementation than policy level. So we say more. It's not that it is not at there. There may be some problem in the policy also, but bigger problem is there at the implementation level. 164 words. These aspects can be transformed into a diagram also. I can just put again in different dimensions, but try to use the entire expression over there in that case, because that will explain. Malnutrition in India is not merely a public health concern, it is also, slight mistake there, it is also a challenge of social equity, human development and effective welfare governance discuss. So not only public health concern, but it is also what concern? Concern. It is a challenge of social equity. When we say challenge of social equity, it means that there's a problem in the social equity which is bringing malnutrition. There's a challenge of human development. Something in human development may not be happening properly where there is malnutrition. But then it's the other way also. That means there is a vicious cycle over here. Malnutrition leading to social equity and human development and social equity leading to malnutrition. Because that problem has to be seen in that cycle itself. Okay, anyhow, let's look at this. The context is the NFHS 6, the report which comes, which is talking about malnutrition. Now there is, of course, certain achievements have been made. So NFHS 6 indicates falling, stunting. We have mentioned the data also over there, in case if you remember, and wasting, but one or two, at some places you will have to mention data also, I mean, especially where it is required. These are the points that will justify your context. Both stunting and wasting are falling, but further malnutrition gaps are attributed to social inequities and effective governance. So this needs to be resolved. That's how we connect it to the question. Okay, let's see. Challenges which are there, challenge of social equity and human development. Okay, so we'll break it up in two parts. Social equity and human development we'll discuss together because they are connected, and then effective welfare separately, because if you treat all of them separately, there will be a lot of there will be interplay, there will be overlaps. So it's better to consider them together. And the first point, let's see, Malnutrition, social equity, and human development trapped in a vicious cycle. How it is a vicious cycle? The three are connected. Again, you can draw a diagram, one leading to the other. More poor human development versus malnutrition. Malnutrition leads to poor human development in what form? It will lead to cognitive impairment, poor learning, poor health and physical abilities, weakening workforce and human development again. So overall, a lot has been said in this one statement. Maternal illiteracy and poor health, this will drive intergenerational stunted growth. I think this could only be, you cannot explain this, there's no scope in this 150 word that you'll explain. Just write it very briefly that how, because if a mother is not healthy, the child will not be healthy and the future generation will not be healthy. Or if the mother is not educated, she doesn't have that awareness, then of course the health and the other issues will get affected. Marginalized groups, they have higher undernutrition rates. This should be there. Higher undernutrition rates. SC/ST, for example, have a higher underweight and stunting. This is just for example. Then the tribal areas, we talk about regional differences, poor health delivery. Also, backward regions have poor health outcomes. Again, related to what? When we say social equity, so even in the regional terms, in terms of gender, or maybe in terms of marginal groups, weaker sections, there are problems. Household wealth dictates nutritional equality. More poor, poor nutritional quality. And intra-household gender discrimination, which is there, right? A discrimination between the girl child and the boy child, because of which also it happens. So this shows the relationship of malnutrition with social equity and development altogether. And the second aspect, challenge of welfare governance. First is poor public health, and I'll just go fast on this because it's pretty easy and it's now getting repeated because something very similar to the previous question. Public health infrastructure problem, lack of last mile delivery, this you all understand, monitoring apps, targeting errors, lack of coordination among agencies, incapacity of functionaries because they may not have the understanding of these groups also many a times, or to address those problems. So then the pseudo approach is followed many a times. Focus on food than nutritional security. Holistic, again, perspective is not taken. So these remain the challenges, and we say that mission portion 2 is now in place, but a holistic policy perspective including administrative feasibility is required to achieve a healthy society. That's how you can concluding remark may vary a lot. I mean, it's just how you just can talk about what lies ahead or the way forward. 170 words. Few things you can skip or combine together to reduce on the number of words per. Next question, number 8. Analyze advantages and limitations of the generalist structure of the Indian civil service in contemporary governance. Now, this question is something which could be answered by having some understanding of administration, right? Generalist perspective. What are the advantages and what are the limitations? So generalists and specialist debate is always there in administration. That is, should we have people who have a little knowledge about all different areas? This is required for administrators, because administrators, they have to deal with very many multiple issues, and especially those who are at the coordination level, like as a district magistrate, or maybe as someone heading the block administration, maybe someone heading the divisional administration overall, the general administration. Then their approach has to be generalist. Even when you are going into the policy making level, sometimes the policy understanding needs, you need to have, different, you have to treat from different dimensions. So the approach has to be generalist. So there is definitely some advantage, but the problem is that they do not specialize in a particular field. And especially if the field happens to be more technical, then we require more technical or bureaucracy, or rather we require technocracy itself. So let us look at the introducing statement would be like, the traditional generalist administration may require metamorphosis. Now this is one word we can use instead of transformation or change. Wherever the structural, especially structural transformation or the process transformation is required, metamorphosis for delivering contemporary governance. So it's important to analyze its advantage and limitation. So we have created a context as to why this question has been asked. Because analysis is important. Why analysis is important? Because we need to change or transform the generalist administration into something more contemporary. So what are the advantages of generalist structure? Coordination requires generalist approach. Coordination, as I told you, you have to deal with very many different agencies or departments. So a little understanding of all different areas is required. Multidisciplinary approach is required at policy making. I'll already explained both these points before. Next is diversified experience of different fields bring better administrative skill. Like for example, an IAS officer. He has worked at different levels and he may have worked in different departments also. At the state level, he may be in the health administration, he may be in the education department, he may be there in the law and order department. So there can be, changes which happens. You get exposure of different types. So in that case, your administrative skill will improve because you are able to deal with multiple different types of exigencies, emergencies, or maybe challenges which comes in administration. Generalists are more sensitive and humanistic because specialists will be more technical people. Technical people are more technology oriented. They are less socially sensitive. So that's why we say that, because generalists has always worked and interacted more with the people. And specialists, they have been working in their, from the environment of their laboratory or from the environment of their workspace, or their mind is focused on to the technical aspect, right? So of course it is relative. Generalists will be, we can say that they may be more sensitive and humanistic, and they bring a holistic perspective in problem solving from different aspects, even problem solving, not only policy making, any other kind of problem solving. Inherent in existing, also this is interesting, that the generalist approach is inherent in the tenure system. Now tenure system generally is someone from the public administration background would understand what is tenure system. I think people with a little modern history also, like knowledge of modern history, also understand that tenure system was introduced by Lord Curzon in 1905. This is an approach in administration where you work for some time at the state level and then you go up to the center on deputation, and then maybe you can come back to state and go back to the center again, but you are working at both the levels. But the initial years you are working at the field level, so you gather a lot of field experience. And once you get a lot of field experience, then you go at the higher level, you go at the level of policy making, and you contribute with better inputs because you have the understanding of the feasibility whether programs, schemes or policies could be implemented because you understand the ground realities. This is how the tenure system has been working, and this will support the generalist system because you are working at the implementation level and implementation also in different departments, and then you gather that experience at the higher policy making level. See, remember, these are the advantages of a generalist because of which we have been appointing, even in some very specialized departments like Indian Audit and Accounts Department, the head, the Comptroller and Auditor General of India, CAG, has been an IAS officer, right? As someone who has completed his tenure as in the service and then appointed over here as CAG. Or the Election Commission, the topmost position, will be of an IAS officer because they are the ones who know about the nitty-gritties of administration in general. So you can also give certain examples of the departments like Election Commission. You can give an example of CAG also over here, that how the generalist approach can help. Limitations. Limitation, of course, they will lack expertise in handling specialized technical issues. That's understood. Brings attitude of self-sufficiency and superiority. They think that they know little about everything, but they think that they know a lot about everything. And this is how they think that we don't require other people. We can handle it all by ourselves. So that brings in the attitude of self-sufficiency and also superiority. Like for example, that's a generalist specialist debate because a lot of IAS officers and the engineers, or doctors maybe, they had this conflict earlier because the engineers and doctors were seen as more superior positions earlier than civil services. Then comes in the civil servants who's acting as a generalist and treating those engineers who got into the government departments and all, they are treating as if they are inferior to them because they are conducting the meetings, the coordinating in which the executive officers of the district, many a times engineers are there. So they have a sense of superiority, and this is what later on was realized by these engineers. They thought, let us ourselves become in the get into civil services. So from late 1970s is a new trend. We have seen that how the engineers and the doctors, they have started to join civil services, and civil service again is seen as something more charismatic, a job, something more influential, a service than the services of engineers or doctors. Emerging issues, more technical and specialized, like e-governance, artificial intelligence. This will again require even more expertise in governance. So it's related to emerging issues. Not open, they have a rigid attitude. They are not open to learning and adapting to new techniques and process because their approach is bureaucratic. They always work in that bureaucratic approach. That also is mentioned. Bureaucratic in approach, more rule oriented. That's their limitation. They have short tenures because short tenures in terms of a particular type of work they are doing. They are working in one department, they are switched to another department. So they are not able to acquire a particular type of skill also because their tenure is short. Difficulty in grasping the issues. And do not promote specialists through lateral entry. They don't want through lateral entry that the specialist comes into the organization because this will cut down on their own power. And I have given example that this becomes more important in case of LPG and new public management. New public management is a paradigm in administration which says that the private management practices should be adopted. But these people are not very open to learn from private sector. Not open to learn from that's a very sweeping statement. Of course, many of them would be open, but the system is such where there is a resistance towards this learning. How we conclude? Overcoming limitations and adapting to new realities of entrepreneurial governance. Entrepreneurial governance means a governance which is innovative, bringing new ideas, a governance which is trying to conserve on its resources and maximize on its output. Which is more business oriented, which is more professional. Information age and technology only could help deliver. It should be delivered to an aspirational society. Deliver to an aspirational society, the term we have taken from the new age governance. Right, we have all these literature of the Niti Aayog which talks about aspiration, the government's programs talking about in terms of aspiration as an achievement for our society, fulfillment of aspirations. I think this question was a little, thoughtful in terms of how you generate dimensions. Okay, so a lot of people who will not bring in as many dimensions or important dimensions, or they become repetitive also, will lose marks. Number of words, 158 words. So I think that's precise. Okay, this is a difficult question, right? It is difficult because this question, the approach of answering is different. Now we don't have this question is from the bilateral, from the international relations or other, let's say the global issues. IPMDA, Indo-Pacific Partnership for Maritime Domain Awareness, bridges the gap between India's Sagar vision and Quad's collective Indo-Pacific strategy. Make a critical assessment of statement focusing on IPMDA. Critical assessment of the statement means you have to criticize it. So give limitations also alongside. But first of all, you have to explain it. Now in this question, I have slightly twisted it in terms of I will focus more on explaining the relationship and not as much on the critical aspect because I wanted to present an idea over here. Okay. So the answer structure which I will circulate, you will get the perfect answer with respect to the critical assessment also. But here my idea is how you will explain this much. Okay. So I'm just trying to make an assessment of the statement only. I'm not doing a critical assessment over here. Okay. Slightly just because something is to be explained. See, there are three things over here: IPMD, Sagar and Quad. You have to relate all three. And then you have to do a critical analysis also of it. So the same statements which you are using alongside, you can do some criticism also that this will not be able to achieve or there's a complexity in achieving it. How to relate is a bigger question. So here, this is not the answer. This I'm just telling you the approach or how you will study certain things. See, in any particular topic, let's say about Sagar, about Quad, about IPMDA, first of all, we need to be very clear about the concept, what it is. What is the vision? What exactly Sagar is, what it is trying to achieve. What exactly Quad is, what it is trying to conceptual clarity has to be there. Second, we should be very clear about the main component in terms of keywords that defines these. Those keywords you have to think. Like with respect to Sagar, I know that there are 5 dimensions in Sagar. That itself is a keyword. In case of quad, there are certain things which it is trying to achieve. They become the keyword. Okay. Now we can pick up when you study, you can pick up from their objectives, from their vision, you can pick up, and when you are studying it, remember to make a list of these keywords. Then only, because when the question is, most of the question you see that how they are all interrelated. You should be able to develop those interrelations. So I have in rough also, what you can do is that you can just think about Sagar, jot down some keyword, think about quad, jot down some keyword, think about IPMDA, jot down some words. And now you have to interrelate. So I have to interrelate these many terms. Now this is not an easy task, it's a difficult task. So you have to just see that there may be certain aspect here and certain aspect here and certain aspect here which will go together. Okay, certain aspect here, certain aspect here, and certain here will go together. They can be related and explained. This is the means of the quad. This is a broad vision. Sagar is a broad vision and it is India centric, means India's vision. Quad is giving a broad strategy that there is a possibility of achievement of many things and what India could achieve through quad, through its strategy. So this is vision, this is strategy, and this is the technique or the method. How will you do it? Because this will be helpful. This is a means to implement the ideas of quad. Right? This is something very, very specific. The IPMDA, you can see that it is talking about detect and respond to illicit maritime activities, illegal, unreported, unregulated fishing, climate events, humanitarian crisis. Something very, it provides real-time information, provides innovative technology, commercial satellite, radio frequency, data collection, etc. It's specific. These are the means through which we will try to fulfill the vision of Sagar for India, following it within the approach of the quad. So let's see how we approach this question. I have told you I am just making an assessment of this. Okay, critical assessment I haven't done here just because I wanted to focus. So just assume that the question is of making an assessment. Okay. In the answer structure, I will provide you both the answers, okay, for critical assessment also. As quad focuses upon actionable strategy for Indo-Pacific maritime security, IPMDA actually provides technical and execution details to transform it into real action and help achieve broader Sagar objectives or Sagar vision. This is how you have related the three. Until and unless you are clear with this concept that what exactly IPMDA under quad and how the three are connected to each other, you will not be able to answer this question. Now in points, so I am just connecting those aspects all which are there given in the table. Okay, how we are relating specifics of the actionable strategy under quad for multifaceted cooperation can be channelized to multifaceted cooperation can be channelized. The multifaceted cooperation is also happening in case of Sagar through IPMDA's innovative technology, real-time information centers and combating illicit activities. Are the specifics what IPMDA could provide for what? To first achieve multifaceted vision under Sagar. What are the vision? Briefly I have mentioned them: maritime security, trade, economic integration, sustainable development, etc. Help India provide net security in the IO. This is another purpose, that it wants to provide security to other countries. So this itself will help. The quad as a platform and the techniques of IPMDA will help India provide net security in the IOR as envisaged under Sagar. And then the third aspect is provide naval aid, intelligence and other assistance services. This is another thing that happens under Sagar, because this will help again in fulfilling this vision of Sagar. So the vision of Sagar we have related with these two. Then further, broad objective of maritime security under Sagar. is possible through linkage with overall security architecture, because Quad talks about security architecture. And this is enhanced with the maritime domain awareness. So the broader terms you see we have interrelated. Overall maritime security, the domain, and the overall security architecture, the broader, and these terms are conforming to each other. We have interrelated. And an alternative maritime security regime to China and rule-based Quad can be aligned with connectivity and infrastructure through ports, naval bases, and digital services under SAR, and accomplished through increased transparency in critical waterways under I. Again, you see, IPMDA uses this phrase. Connectivity and infrastructure has been used under SAGAR, and alternative maritime security regime to China has been used under Quad. So that dimension of Quad also we have used it over here to answer. I believe that UPSC should not have given this question as critical for critical assessment, because a question, it loses its essence. The moment we will start doing the critical assessment, right, the focus will be on the either IPMDA or on the Quad. So I think it should have better been to explain either, or to establish a relationship, or to make an assessment. But anyhow, critical assessment, I will give you the answer there, because I just wanted to explain this aspect. So I have just covered only this much. Treat it as an assessment of this. Therefore, there is a possibility for re-emphasizing on SAGAR through IPMDA and Quad. This is 169 words. I will give the alternative answer structure also for the critical assessment. But of course, it will be based upon this only. It's just that we have to alter all these statements. Last question, number 10. BRICS acts as a powerful counterweight in global governance, actively amplifying the voice and influence of the, for this session, this is the last question. The other set of answers I will be giving you as a separate video. All the 250 word questions will be in a separate video. In fact, that will be 250 word question is easier to answer than 150 word, 50 word, because making it compact becomes a challenge, because many times you know a lot when there's no space to write. And we have seen UPSC many times that what it does is that the question which should ask for 250 words, it is asking for 150 words. The ones which should ask for 150 words, it is asking for 250 words. BRICS acts as a powerful counterweight in global governance. Okay, so basically you have to talk about the role of BRICS, right, in projecting itself as an alternative to others. I think this was the easiest question in the paper. So created in 2006 and premised on creating an alternative platform to Western dominated institutions, BRICS intends to increase the influence of the emerging nations. Just an explanation of the question, going into a little context of its creation and purpose. What are the roles? Role of BRICS as alternative to other grouping. I think this you fairly know well. I not to explain anything. Just quickly go through this. Let's see if any point is to be explained. I will do that. Presence of rising power, alternative influence, strategic. What is important here are the precise expression, which is also explanatory. That is what you have to focus. Okay. Now, whether you put it in from some form of diagram or structure, blocks, or you write in the point form, but the expression has to be precise, which also explains these points. So countering Western dominated global institutions, this already is known, IMF and the GS and other. Geonomics orientation, challenging existing financial hegemony, that is through creation of new development bank, contingent, reserve arrangement. These are all factual, you already know that. That's why I say this is the easiest question. De-dollarization, trade in local currencies, reducing reliance on dollar. I think content is less important here. What is more important are the explanatory expressions. Okay, how much you need to explain, to what extent. Advocacy for representation in global organizations, reforming UNSC. Negotiations on global issues like all these, for example, and alternative forum to coordinate international governance like these issues, trade, investment, climate finance, maybe food security, and all of that. Its informal, non-military nature provides enlarged engagement flexibility, because it is informal group, right? Non-military, so the countries find it far more easier to associate. Rather, they may not have to take very strong positions on certain issues. So it provides the flexibility. Raising voice of global south amidst irrelevance of other platforms, because it is about other groupings, right? So not just about the Western oriented, but you have to also see that this may even replace some other platform which have become irrelevant. Its working faces challenges of conflict. So we are talking about the challenges and then how we can go ahead. Its working faces challenges of conflicting and cross interests. Conflicting interests and cross interests. Conflicting interests between like the two countries which are both members of this. So there is a conflict among them. And cross interest is because it US China, like Western domination you want to end, but then you have to do something with the West. But persistent and diversified pragmatic engagements may help in dealing with these. Okay, so that's all. And I just repeat that. Please follow us on the YouTube channel, both of them. This one is English one. And Hindi वाले का आपको link दिया हुआ है नीचे YouTube में. You can join that Hindi YouTube channel as well. I mean, we have just created that channel and we'll be posting very meaningful content over there in both these channels from now onwards. And I have already made an announcement of the current affairs, polity and governance current affairs monthly. I will be presenting every month. That will be there. And in between, I will also deal with whenever any important issue comes, I will come up with that video in detail on that particular issue. And please do follow the Telegram channel also. The link is given below for other content and for the PDF of this. And the next part of this will be released within 2 days. Okay. Thank you so much for joining.